Mom said I get the bank account. Mom said I get her insurance policy. Mom said the house would be split up 3 ways between my brothers and sisters. Mom said I get this. Mom said I get that. We get calls from sons and daughters all the time who are very upset because at every single family gathering, mom said something. Mom said at Easter, mom said at Christmas time, mom said at Valentine's Day, mom said at the barbecues in the summertime, at the 4th of July parties. Mom would say at some point in the conversation that her house or her bank accounts or her insurance policy, whatever it is, that it was going to be split up 3 ways between her 3 children. And this happens all the time. And I don't know if it's because the mother or father or whoever it is just embarrassed and don't really want to talk about what they really want to happen in their estate, or if sometimes they also just don't understand what the process is and what they might be doing is not going to accomplish what they actually want. This is what happens is mom says, again, at all of those family gatherings, let's use a house as an example. She says, my house, it was going to be split up 3 ways when I pass away, when I die. And so mom, thinking that she does not want to go through the probate process, she does not want her estate to go through the probate process because maybe she had to probate her mother or father's estate and she saw how expensive it was, that it cost several thousands of dollars and it took a long time. It took 5 months, 6 months, 8 months, a year, whatever it is. It took a long time for her to probate her parents' estate. So she does not want her 3 kids to have to go through that process. And somebody somewhere told her that a way to avoid probate is to simply put your house in joint tenancy with one of her children. And then when she dies, that child can distribute the property to their other 2 brothers and sisters. Well, this creates a problem, and I bet you can already see what it is. When mom puts that house, the house that she's living in, into joint tenancy with right of survivorship, let's say she does that with her daughter, Monica. So she puts that house in the name of mom and Monica as joint tenants with right of survivorship. And that's very important because now that she has done that, when either Monica or mom dies, the other one automatically gets that house. Do you see the problem here? So let's play this out as if mom had died first. So mom dies, then Monica is now the surviving joint tenant of that house. That means that house is 100% Monica's, and she does not need to share it with her other 2 brothers and sisters. She could if she wanted to. If she did that, I would probably advise that she seek a tax professional to see exactly how that is going to impact her, because now she has an asset and she's giving away 2/3 of that asset to somebody else, or she's selling that asset and she's giving 2/3 of the money to somebody else, to her brother and sister, right? So there could be some tax implications there, and if she's gonna do that, then she has to be really, really careful. But the bigger problem is that Monica doesn't have to do that if she doesn't want to. And this makes families very, very upset because Monica is now 100% owner of that house and it's hers. And if she's married, 80-90% of the times, the husbands are gonna say, no, that's our house. It was in joint tenancy. You are now 100% the owner. We don't have to share it with anybody. Your mom said that at every family gathering, but that's all she did. If she really meant it, she should have put it in writing, and mom never did. But let's follow that line of reasoning as well. What if mom did have a last will and testament, and in that last will and testament, she said, my house goes to my 3 kids in equal shares. They each get 1/3. However, because mom put that house in joint tenancy with right of survivorship with Monica, Monica gets the house because the house transfers to Monica outside of the probate process, outside of the will. And because mom has done that, the will does not have any jurisdiction over that house. You see what I'm saying? What mom should have done instead is not done anything. I mean, she went out and got a will, right? And if she just followed the language in her will, the will says that it goes to the 3 kids. So if she had just kept the title in mom's name, done nothing, then yes, it would have to go through the probate process. But in the probate process, it would go to her 3 kids. Now, how could she avoid probate? Well, mom could have gotten a revocable living trust, centered estate plan during her lifetime, and put that house into the name of the trust. Now, because it's in the name of the trust, when she passes away, her successor trustee would take over and simply sell the house and divide the money between the three kids, Monica and her brother and sister. But like I said, because mom did it as a surviving joint tenant with Monica, Monica gets it 100%, and it's Monica's decision what she wants to do. And she may have had conversations with Monica outside of the other kids that says, I really want you to have that house. Who knows? It doesn't matter. Oral arguments, none of that matters. It has to be in writing, and mom put it in writing, and she put Monica as the surviving owner of that house. This also happens with bank accounts. We see this probably more than the houses. Mom will put one of their sons or daughters, let's just continue with Monica, puts her as a joint tenant on her bank account, or puts her as the pay on death beneficiary on her bank account. So when mom passes away, that money automatically becomes Monica. So if mom had a nice little nest egg, let's say $75, $80, $100,000 in her checking account or her savings account, and she put Monica as the pay on death beneficiary, then the second that mom breathes her last breath, that money belongs to Monica. All Monica has to do is go to the bank with a death certificate, probably show an ID that she really is Monica, and the bank will write her a check for whatever is in that account. Now, again, if there's a last will and testament that says that it's supposed to be split up between her three kids, it does not matter, because what matters is what's actually in writing, and that bank account would fall outside of the probate, outside of the last will, because it just automatically goes to Monica, and Monica can do whatever she wants. And I'll tell you something, guys, people do this all the time. I cannot tell you how many stories over the last 20 years where moms and dads have told their kids that they're gonna split their estate evenly between everybody, but in reality what they do is they go down to the bank account and they only name one child as the pay on death beneficiary. So the bank only pays out to that one child, and it really makes the other two sons and daughters very upset, and they try to take legal action. But as long as mom or dad made that designation when they were of sound mind, that they had capacity to do what they're doing, then it stands. It's going to be very hard and very difficult to fight something that mom or dad may have done years ago. And that is actually what we see is moms and dads do this many 20, 15, 10, 5 years ago, whatever it is. It's not something that they just thought of. They did it many years ago, and they had all of that time to change it, and they didn't. And that's another key, is they had the opportunity to change what those designations were, and they didn't do it. So this all comes up a lot. If you are the mom or dad and you're thinking that by putting a house in joint tenancy with one of your child is going to work, or you think having a bank account as a POD on just one of your bank accounts is going to work to split it up equally, I can tell you it's not. That child who you're giving everything to, it belongs to them 100%, and it's up to them whether they really even want to share it. And I will tell you, in most cases, they don't. If mom really did want that bank account with $80,000 in it to go to her three kids, then instead of just putting Monica as the pay on death beneficiary, she could have put all three of her children as the beneficiary of that bank account, of the pay on death beneficiary. Then when she did pass away, if that bank account was her only asset, those $80,000 were her only asset, then at that point, the three kids could go together with a death certificate with their identifications, probably sign an affidavit, and the bank would write them each a check for a third. But if she just puts it in Monica's name, it just belongs to Monica. It doesn't matter what mom or dad said at all of those different family get-togethers, that this house belongs to all three of you, or this bank account belongs to all three of you, or this insurance policy will go to all three of you. I didn't even talk about insurance policies, but it's the same thing. If there's an insurance policy and you only name one child as the beneficiary, the insurance company is only going to pay out to that one child. They do not care about the other two kids. So if you're thinking about this, even if you're wanting to avoid probate, don't listen to that friend at the grocery store or the hair salon or the mechanic's garage, wherever it is, where you get your information. Book an appointment with an estate planning attorney. Even if you don't hire them to do anything, see what your options are in your jurisdiction, where you live. See what it's going to take to possibly avoid probate. You always hear me say that I love revocable living trusts, and I really do. I think they are a great vehicle to avoid probate, to protect you during your lifetime and after your lifetime. But if you have a small estate, maybe you just do have that one bank account. Maybe you don't even have a house. Maybe you're in in an apartment, your car is paid for, maybe you don't have a car, and your only asset is a bank account, then maybe we do not need to have a revocable trust. Maybe there does not need to be a last will and testament. Maybe you just need to make sure that your beneficiary designations, your pay on death designations are up to date. And that is a way to do it. But again, talk to an estate planning attorney to make sure that you do this right. Because if you don't, what you intended to do may not actually happen if you only name one of your children as the beneficiary. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.